Hello, everyone. We are starting our streaming shortly in about 10 seconds. All right, the clock has ticked to 12, so we can get started. Thank you. Welcome, everyone, and thank you for joining today's session on H1B Cap 2026. I'm joined alongside Prashanthi Reddy. Prashanthi is an award winning immigration attorney specializing in immigration law. She has recognition and awards from many distinguished and prestigious organizations. She has been recently listed by Forbes as one of New York City's best immigration lawyers in 2024, amongst other achievements and recognitions. Prashanthi, we can start today's session with an immigration update. So over to you.
Yeah, if you can get the slide. So today's session is mostly going to be driven by the audience because we're hoping to do a question and answer session. We've also gathered questions from our website and questions that have been asked on YouTube from our YouTube channel. So we'll be answering those questions as well. And maybe some frequently asked questions. And of course, live questions from the audience are uh, always welcome, and we look forward to those. So please start posting your questions in the chat. We will begin by giving you a few updates. One important update with reference to H1B filing this cap season is, of course, we have to talk about the RFEs, what kind of RFEs we're seeing recently with reference to H1B cap petitions. And when one of the most surprising RFEs that we saw is has been reported also by AILA, American Immigration Lawyers Association, but we've received multiple reports of a new trend, RFE trend, basically in all employment-based cases, not just I-129s, but I-140s as well. And the RFE is basically stating, and I quote, "We have encountered potentially adverse information related to the beneficiary. To continue processing your application or petition, we require an updated address for the beneficiary so that we may collect biometric data. Please submit the beneficiary's current and updated residential address and the end quote." So this is what they're asking the RFE. Some RFEs, of course, are not, most of the RFEs, or I must say really all the RFEs do not specifically indicate what adverse information they have and why they want the biometrics to be done. Um, and most probably after you give the address, they'll ask you to come in to a biometrics office for the beneficiary to do the biometrics. We think that this is the same thing as what was done with reference to the CVIS revocations. So if you've had any encounter with law enforcement, if you've ever been fingerprinted by law enforcement, even if it's for a traffic violation or any other petty offense, I think we're seeing these kind of H1 RFEs as well. So they're basically, again, using mining information from, I guess, the FBI records and sending out RFEs automatically for maybe beneficiaries who've had some kind of encounter with law enforcement in the past, whether they've been charged, dismissed, whatever the case might be, and no matter what the offense is, even if it's a simple traffic violation. AILA has, of course, reached out to USCIS to express concern about these RFEs and also to ask what USCIS intends to do with the biometrics information. What should we do in these cases? I think simply giving the biometrics, the current address of the beneficiary may not be such a good idea, because we suspect that if the beneficiary then is called for biometrics and appears in person, they might actually detain the beneficiary. is what we're worried about. So instead, at least what I plan to do and what Ayla is advising is to reach out to USCIS in the form of a response asking what kind of adverse information they have. And there is um, the law is that they should give us all the information they have, and that the beneficiary is able to then respond to whatever information that they have. That is the law, that is due process. And the law that requires this is 8 CFR 103.2, small b 16, small I. So I would suggest that if you do get such an RFE, to respond under this section, asking for the adverse information that they have. Next slide. And this is the section, derogatory information unknown to petitioner or applicant. If the decision will be adverse to the applicant or petitioner and is based on derogatory information, consideration by the service and of which the applicant or petitioner is unaware, he or she should be advised of this fact and offered an opportunity to rebut the information and present information on his or her own behalf before the decision is rendered. So this is basically, under this law, your USCIS is supposed to provide that derogatory information so that the beneficiary may rebut it. So we're still waiting for more information, of course, with reference to what USCIS is, why USCIS is asking this information, and what information they have, which is derogatory, and what they intend to do with the information once given to them. So we recommend also that if there are any employers out there or beneficiaries, that if they do have had some kind of encounter with law enforcement, that they inform the employer so that the employer might make a proper decision as to how to file the H1, when to file the H1, what information to put in the H1B filing, when sending out the H1. Next slide. So yeah, this is just more of the same. As I said, once they come in for fingerprinting, it's possible that ICE can then detain them. So we want to be careful when we advise clients to go in for biometrics appointments, especially in this scenario. Also, we've been seeing some other RFEs, mostly related to related to contracts and work orders. So we're also seeing RFEs related to maintenance of status. So as per the new regulation, you have to maintain status and you have to show proof of status, especially in extensions and amendments. So that's not cap cases, but it's definitely in extensions and amendments. And in cap cases, if you're on an F1, then they expect you to provide maintenance of status documents to show that you maintain status on your OPT or CPT, or maintain status on your student status. So it's important to provide documentary evidence to this effect beforehand, rather than waiting for an RFE on this same topic. Another kind of RFE could be, again this year, which we have not seen last year, is with reference to availability of specialty occupation work. So if you do have, you're filing a H1, you have to show evidence that you have work for that particular person. So if it's a consulting company, then you'd have to show the contract or the purchase order with the end client. If you are not a consulting company, then you have to show your volume of business or give an explanation as to why you need this beneficiary. And if you've hired similar people in the past, maybe you can say you're expanding, or maybe you can say that you've opened a new line of business and that's why you need this person. Whatever it might be, an explanation in the petitioner letter might be useful, along with a tax return or contracts that you have with your client in general to show volume of business. That is with reference to H1B RFEs. In addition to that, I wanted to touch upon CVIS terminations. This I have talked about in my previous videos. There are a lot of videos on YouTube. Go and watch them. But there's been a sharp uptick in sudden CVIS terminations. The CVIS terminations are being done by not by the DSO, which is generally how CVS terminations take place, but it's being done by ICE, and ICE is sending out emails. In addition, they're also getting emails from the Department of State stating that their visa has been cancelled. So most students are getting both kind of emails, visa termination as well as CVS termination. And again, the reason is the same as the H1B RFE reason. If they've had any encounter with law enforcement and they're given fingerprints, that data is being mined, and emails are automatically being sent out without looking to see on a case-by-case basis whether the CVS has to be terminated or not. In this instance, I suggest, and you could maybe go to the next slide, I suggest students contact their DSO. Also, if possible, and if the DSO agrees, maybe file for reinstatement. Also, avoid any kind of travel because you may not be able to come back. And if possible, file a lawsuit. I think filing a lawsuit in federal court might be the best option for you right now. And a lot of lawsuits are already in process. Many have already been filed. There are quite a few class action lawsuits, so you could join one of those class action lawsuits, and the fee will be less for you because there are many people and the attorneys won't charge the full fee. So that might be a good idea, filing a lawsuit, because a lawsuit could ensure a TRO, a temporary restraining order, asking the judge to reinstate your CVS at least temporarily until the case is decided. And in which case, then you could always file a change of status then from an F1 to a H1 if your cap has been picked, while the TRO is pending because you are in status at that time. So please remember that if you get a CVS termination, ICE can come and pick you up. It is possible that you're out of status. It's questionable as to whether the unlawful presence clock starts ticking or not. The unlawful presence law basically says that if you're out of status for more than 6 months, then if you leave the country, you cannot come back for a period of 3 to 10 years. But at least as per the present interpretation by USCIS, unlawful presence does not happen with students who are in DS, duration of status, where they don't have an actual I-94 end date. Next slide. Let's also touch upon quickly the May visa bulletin. This is the latest visa bulletin which came out last week. So the visa bulletin pretty much looks the same as it did last month in April. In April, we saw a lot of forward movement. But in May, we are seeing no forward movement at all. For EB1, India and China, they remain the same. And for EB1, all other countries, the dates are current anyway, so they continue to be current. Next slide. EB2 also is the same. There's no change in India and China for EB2. All other countries also no change. For EB3, there's some reason for optimism because there is a slight change. There's an advancement of 2 weeks when compared to April visa bulletin. So we are seeing kind of a steady advancement in the EB3 category. On the other hand, dates for China and all other countries remain the same as the April visa bulletin for EB3. So only India advanced by 2 weeks. Next slide. For EB5, bad news, there's a retrogression for India. It went back by 6 months, EB5. So there's a lot of demand. This shows that there's a lot of demand for EB5 unreserved category, that is the regular category. The dates for China have remained the same. So no change for China, but India, there's a retrogression of 6 months. Next slide. And yeah, that's it for the updates. We can start with the questions.
Yes, and this is a good reminder that today's session is predominantly to help answer any questions, queries you have. So if you would like to participate, if you have a question, If you are joining us through one of the streaming platforms, whether it is Facebook, YouTube, or LinkedIn, you can put in your question directly there. And for those who have joined the stream, you can use the chat window to drop in your question. We'll start with a few questions that we have from our YouTube channel. And this is again a good reminder. If you have not subscribed to our YouTube channel, it's a good opportunity for you to go and subscribe to our YouTube channel. There is a lot of very helpful, meaningful content that we are publishing pretty much on a daily or a very regular basis. So on that note, one of the first questions is, my H1B visa extension is approved. When will I get the hard copy of I-797 document? After how many days?
This Caroline, basically the H1B approval takes about 10 days for you to receive it by mail. The employer usually receives it, by the way. You will not receive it if you're an employee, so you have to get that from the employer. It takes about 10 days. Sometimes it could take a month. And, worst case scenario, they are, it could be lost in the mail as well. But the good news is, if you file online, and I encourage everyone to file online, then it's possible to retrieve the approval notice online as well. So at least you have a copy. Yeah. And so it takes about 10 days. It could take longer. Sometimes it takes a month. Worst case scenario, the post office or USCIS sometimes don't mail it out to the right address, or the post office messes up sometimes. And to avoid that, it might be a good idea to file online. So at least you have access to your copy of your approval online.
All right, I'll move to the next one. I'm selected as Master Cap, but my degree conferral is May 31st. Can my employer file LCA before 31st May and file the H1B petition later in June after degree conferral date, or has to file even LCA after 31st May after degree conferral date? Please guide. Mean for LCA degree is needed or not?
So I'll answer your question, but I also have more information to give you, which might help you and make you happy. But generally, you have to show that you're eligible to file a H1 as of the date of filing the H1, not as of the date of filing the LCA. So, to answer your question, as long as you qualify for the position as of the date of filing the H1, you can file the LCA ahead of time and then file the H1 when you qualify. But in this particular instance, degree conferral is not needed, in the sense that as long as you can show that you've met all your requirements towards your master's degree, and you have a letter from your school stating that you've met all the requirements, you don't have to wait for the actual degree to be issued. So you can actually file your H1 in May itself, even before your degree is issued, and which might be a good idea because you don't want to file in the last moment. And as long as you have a letter from your school stating that you have met all the requirements towards the master's degree, that's all you need. The actual degree can come later. You don't need it for filing the initial H1B.
Great, thank you. Um, I'll move on to some questions that we've received from our website. And I can also see many of you have started to share your questions on the chat window. Great, thank you so much for that. We will be answering them shortly. I would also remind you that when you're putting your question, just be precise, and if possible, just put all the information and your question in one single text. That will help us go through and answer properly. Question from website. This is from Akram. I'm an H1B visa holder who has filed her GC via NIW in October. It's 3 months that my employer has failed to pay my wages. I resigned and I'm about to start working for a new employer using my pending GC EAD. Do you advise to report my former employer to USCIS for violating H1B?
That is your prerogative. That's up to you whether you want to do that or not. From your status point of view, you want to make sure that you're not out of status. And usually, in order to, it looks like you have your GCEAD. But the question is who filed your GC, who filed the I-140? Is it the same employer that did not pay? Then the question is where you left without an employer for a period of 3 months. And also the question is, did you do an AC-21 change of employer, and are you eligible to do that before joining your new employer? So all these questions are valid, and all these steps need to be taken. Um, as long as you've safeguarded your status, then you can make a decision as to whether you know you need to report it or not. Usually, in order to safeguard status, what employees will do is they'll complain to the labor department, and they'll get a copy of the complaint, and then they'll attach it to their request for extension of H1 or transfer or whatever it might be, to show that the employer has not paid and they have been working. So it is not they have not violated their status. The employer, it's because of the employer's action that they don't have a pay stub. So that generally USCIS will consider that, and they will, in those instances, allow you to change or extend status. In this instance, maybe that's not a requirement that you complain for DOL in order to get back into status. But if you think that will help your green card in the future, because you want to make sure that USCIS does not say that you didn't work for the employer in those 3 months. So in order to ensure that you have proof that you worked, maybe you need to get some documentation, and maybe complaint to DOL is that a document trail that you need, or maybe there's some other document trail, maybe emails or other proof of work to show that you actually worked during those last 3 months. It also could be your timesheets to show that you actually worked.
All right. Next up, this question is from Nageshwarao. My H1B got approved in 2022. At the time of interview, 23rd November 2022, they gave me yellow slip of 221 G. Still, as on today, there is no progress in my case. My employer might not been supported with the USCIS questionnaire since they are US local consultancy. My approved H1B validity until 30th September 2025. Can I go to the extension with any new employer? Please help and suggest.
So in this case, just to sum it up, he had a visa interview. The visa was not approved. It went into administrative processing, and this was in 2022. It's possible, if he's not in touch with his employer, that there might have been a decision, and they might have asked the employer, sent an email back to USCIS asking them to revoke the H1, the approved H1. And then what happens is USCIS will send a notice of intent to revoke to the employer, giving them 30 days to respond as to why it shouldn't be revoked. So it's important to find out what happened. If there was a revocation, then you are definitely not cap exempt, and therefore you cannot file a H1 with another employer now. If you do want to file a H1 with another employer, you'll have to go through the cap, meaning you'll have to again go through the lottery system. So it's important to find out information as to what happened in your case. If it's just a 221G which is still pending, or maybe a 221G that was denied but H1B was actually not revoked as yet, then you might be eligible to file a H1B cap exempt counselor processing petition through another employer.
All right. We'll go to the next one from Yogi. Can one file the cap and non-cap H1B together? What things need to be kept in mind for this? Let's say if someone working part-time under NGO slash professor and also with the corporate employer.
Right. So the reason that Yogi is asking this question is because, for those of you who don't know, if you are working on a cap exempt for a cap exempt petitioner, even if it's part time, you can then file for a concurrent cap subject petition. So this is one way of overcoming, the cap work part time for cap exempt petitioner, like for a non-profit or a research organization or a high institution of higher education, and then file a concurrent H1B uh, for cap subject employer, like a regular employer. But you have to keep in mind that the corporate employer or the cap subject employer has to be a concurrent H1. That has to be a concurrent H1, which means that you should first file the H1 with the NGO or the professor. Once it gets approved, then you have to file a concurrent petition with the corporate employer. I don't think you can do both at the same time. But you could do one premium processing, get it approved, start working there, get a pay stub, or just start working there, and then file another one through a corporate employer. I hope that answers your question, Yogi.
All right, fantastic. So these are some extra questions that we have. So perhaps what we can do is, Prashanthi, we can start taking questions from the live audience first, and then if we have time, we can come back to these.
Sounds good.
All right. We have a question from Bhavya. I think if I'm reading it right, it's if we go with the counselor H1B, do we have to run payroll before transferring to other employer?
Uh, well, if it's counselor processing, then if you're asking me if you need to start working for the employer even before the case gets approved, no, you don't. In fact, if it's counselor processing, you cannot, because no I-94 will be issued. So you have to wait until you file the H1B counselor processing petition, get it approved, leave the country, come back with a valid I-94 as per your new I-797 H1B approval. And once you come back, that's when you can start working for the employer. You actually cannot start working for the employer before that.
Okay. Next question is from Nataraj. I missed filing an amendment for one of my consultant. It's been 5 months already. Is it advisable to file an amendment now, or should I wait for any new contract?
Well, the sooner you file the amendment, obviously, the better. But there is an issue here because you've violated the terms and conditions of the H1. So, as an employer, there is an issue for you, and as an employee, there's a big issue for that person because they're out of status. Unless you can justify that it is within the same MSA, then maybe you don't need to file an amendment. I don't know what the amendment was for. It could be that it's for change of work location, from what you're saying. But if the work location was within the same MSA, it's possible that you may not need to. But if that's not the case, that is, if it's not in the same county or within commutable distance, then yeah, you're in trouble. So you could file a nunc pro tunc H1 based on humanitarian grounds and say that you forgot to do it. And sometimes USCIS will approve these amended petitions. If they don't, then the only way to correct this is by leaving the country and coming back, and then coming back on that H1, and then you'll have an I-94. Then you make sure that they are working at the right work location. Of course, I think that might be the best, because right now USCIS may not even know that an amendment was needed and it was not filed. But if there is questioning at CBP, at the port of entry, presuming that there's already a visa, stamped in this person's passport. Then at CBP, they might ask, what's the LCA work location? Where are you working? They will obviously see the address from the pay stubs, etc. So if there's secondary inspection, that then the person might be in trouble. But if they're just being waved in at CBP, then this might be one way of ensuring that the person gets back into status quietly.
Okay. Next one is from Narottam. Visa approved and got 221G. When can we get an answer from the USCIS?
Well, 221G is not from USCIS, it's from the Department of State. It's administrative processing for your visa. Usually it can take 6 months, it can take 10 months, it can take a year. Usually takes under 6 months. But if they are investigating something with reference to your employer or you're investigating something with reference to you, that can take time because they are backlogged. So I would give it about a year and sometimes even a year and a half. And if you don't hear anything by that time, then you can also file a mandamus claim. Your employer can file a mandamus lawsuit in federal court, asking them to adjudicate the case. But in general, it should take about 6 months.
All right. Next is from Sridhar. Many consulting companies are facing the client letter issue to transfer/new H1B quota. Due to the current job market conditions, what is your suggestion on transferring H1Bs without client letter?
As I was mentioning with reference to RFEs that we are getting, there are RFAs with reference to availability of specialty occupation work. So if you file it without anything, you might get an RFE asking for proof of specialty occupation work. And if you don't have it, then the H1B can get denied. So you can certainly file without anything, and if you don't get an RFE, then great. But if you do get an RFE and if you don't have documentation, then you're stuck. Then you might have to withdraw your H1B petition. As long as you're willing to do that, I mean, you can take a chance. But most likely there will be an RFE asking for specialty occupation work availability. I mean, I understand that a lot of H1B petitions are filed and USCIS cannot send an RFE on every one of them. So that could work in your favor, but yeah, you should expect that there will be an RFE.
Okay. Before I take the next one, I would like to remind everyone, if you have questions for Prashanthi, you can definitely ask them now, whether it is through the streaming platform directly or from any of the social media that you're viewing this stream. Next one is from initials PN. H1B was approved via consular processing. Still need to leave the US to get the visa stamp, or can adjust my status here in the US.
If you're presently in the US and if you're presently in status, then you can file for a change of status, cap exempt from your status. Maybe it's an F1 status, I'm not sure what it is, but from F1 to a H1. Or you can file for kind of an amended petition asking for change of status to be approved from F1 to H1. So you don't necessarily have to leave the country. You can do that by remaining in the country as well. But of course, every time you file something with USCIS, it's considered to be a new petition. So you have to submit the documentation and you have to show that your new petition is approvable as well.
All right. Prashanthi, these are all the questions that we have from the streaming today. We will still give it a couple of minutes. If anyone has any other question, now is the time. You can drop in your question, and we still have a few minutes.
Are there any questions on the website? I mean, on the social media platforms?
Yeah, if they are, I'll be able to see, so that I'll put them across to you as soon as we get any. But these were all collective questions that we've received so far for today. Very quickly, actually, we do have a question that I would like to go back to. Before that, here there are a number of ways we can assist you, whether it is for student visa, travel, work, or green card. Do reach out to us. You can reach out to us on multiple different platforms across social media and through our website as well. Prashanti, next question is from Vashishta. I have two questions from my prospects. One, as a master's student graduating in December 2025, am I eligible to apply for the H1B lottery in March 2025 under the US master's cap if even if my degree isn't officially awarded by the time of registration? And question number two is, what specific steps should I take now to ensure I can legally work in the US without interruption after graduation, especially if I get selected or don't get selected in the FY 2026 H1B lottery? There
So,
was a connection to 2026. Yeah.
right, okay. So, it looks like they filed their registration now in this year, and their masters, they're getting their master's degree. They filed under the master's degree cap, but they're not getting their master's degree until December. So the question is whether there's a long gap, right, between now and December. So the question is, did you complete all your requirements towards a master's degree then? If you have, then we need to get a letter from your school showing that you completed everything, all your requirements, course requirements towards a master's degree, and maybe your graduation is scheduled for December. If that is the case, then you can file um, right away under the master's cap. If that's not the case, then and if you file your registration under master's cap, then you made a mistake in doing that, so you will not be able to proceed with that registration, unfortunately. Um, the second question is, can I legally work in the US without interruption after graduation, especially if I get selected or don't get selected? If you get selected, then of course you can transition and you can use the cap gap rule, and so there will not be any disruption in your work. But if you don't get selected, then you need to move to OPT, post completion OPT or CPT, and there should not be any gap there as well, as long as you do everything in a timely manner, because everything is time sensitive. So you need to file your OPT, post completion OPT, in a timely manner so that there is no interruption. Nowadays, there are RFEs also with reference to OPTs. So I suggest using your DSO's help or using legal help to file that OPT that you have, just to ensure that there is no gap in your employment.
All right. Next question is from Chandra. We are planning to file an H1B Cap petition for a new candidate who will be starting on an in-house project with our consultancy company. Is it safe to proceed with an in-house project setup? And what specific document should we provide to USCIS to support the in-house nature of the role and establish a valid employer-employee relationship?
So there is no requirement of employer-employee relationship anymore, Chandra, so that we don't have to worry about that. In-house project is always looked at, with suspicion by USCIS. So if you really do have a project, and if you're a project-based company, or even if you're a consulting company, but you're doing a few projects here and there, as long as you have proof that you have a project, so you have a contract, you have a PO with whoever you're implementing the project for, you have the project report, you have proof of the project if it's already live, and you're able to show all this. There's other things that you can show as well. You can show, if you have a patent, then you can show that as well, that you have taken a patent for your product. If you have, you're on an app, so if you have, you bought an app store, if you have an app store, so you can show that as well. If you have spent money on the project, you can show that as well, that you have hired maybe an outside company to do the work for you. It's important to show the project timeline, the finances involved, the people that are involved in developing this project. So these are all the documents that you can show in order to get an approval. But keep in mind, there's a lot of documentation needed because there's a presumption, I think, of fraud really when you used in-house project. So it's always, the more documentation that you can provide, the better.
All right. Next question is from Bhavya. Before a change of status with one employer of H1 got through consular process with another employer, is it necessary to run payroll?
If you want to stay in the US, before you leave, you have to always maintain that you always have to make sure that you're in status. So if you're continuing on an F1 status since the H1 got approved for consular processing, then you have to continue to maintain your F1 status. If you're on OPT and that requires payroll, then you have to maintain payroll to continue to be in whatever status you're in. If the change of status gets approved with the other company, then once the change of status gets approved with the other company, then you have to get onto the payroll of that company. Once the H1 gets approved, as of October 1st, actually, even if it gets approved before that, it's only as of October 1st that you have to get onto the payroll of the company that filed your H1, the second company. But as of now, you have to maintain your status. So whatever is required to maintain your status, you need to do that. If that means continuing payroll with whichever employer you're with to maintain your OPT, you have to continue payroll with them.
Okay. We will still be accepting any additional questions. However, I would like to add that for those who are streaming today's session, we are offering an early bird complimentary session. All you need to do is, if you're interested, to put your name through for an early bird complimentary session. You can either share your email here on the streaming platform, or you can email us at prashanthi@reddyesq.com, and someone from our team will reach out to you. Prashanthi, I do have a follow-up from Sridhar. Many people are losing / lay off their jobs who are on H1B. They are not getting a new employer to transfer the H1B. What is your suggestion for those types of people?
Those type of people file for a change of status to a B2. And if you want to stay, if you think that it will take longer for you to get a job, depending on what you think the job market looks like, you could also file for change of status to an F1. Remember, B2 change of status actually not taking long now. Before they used to take a long time, especially if you file them online. B2s are getting approved within a few months. So B2 is definitely a good option for you to use, unless the present administration does something with that and starts making it difficult to file a change of status. But as of now, B2s are getting approved quite easily and quickly. So I would change status to B2 because that will give you at least 6 months of time to find a job, and then possibly an extension of another 6 months. But of course, during this time, you cannot work. So you might want to change to an F1. That's another alternative. And if your school is offering a work study program, then you could possibly get CPT, Day 1 CPT, and continue working that way by changing to an F1. And F1 does have premium processing, so that's the good news. Yeah, so if you're able to get admission, then F1 is also a good way of going about it.
All right. That concludes all the questions that we have for today. Prashanthi, I would request you to stay online for another couple of minutes for any other questions that we may have. In the meantime, for those listening or streaming, feel free to drop in your email either on the chat window or directly to Prashanthi at reddyesq.com. And someone from our team would be happy to reach out for an early bird complimentary session. Prashanthi, there's a there's a new question here from Abid. Once we get selected in lottery and get H1B approved, but did not travel to US till H1B visa expired with that employer, if another employer wants to file new H1B petition, then we can come under cap exempt or again have to go through the lottery system.
So, what is cap exempt and what is not? The definition keeps changing, the interpretation of that keeps changing, and as of now, it's a very liberal interpretation. So, as long as you had a H1B approval at some point of time in the past, whether you used it or you didn't use it, you are cap exempt. So, in your case, you should be cap exempt. But I have heard that the present administration is getting stricter with their interpretation of who is cap exempt and who is not. And I've heard that there have been some RFEs on this subject, and that if the person has not actually started working on a H1, they have said that they're not cap exempt. But I definitely worth a try because I'm hoping that's just an exception but they're still continuing to process uh, cap exempt petitions or define cap exempt in the same way as they've done in the past. Um, I would definitely give it a shot because as of now, I think it's still cap exempt.
All right. So Vashishta has another question. Question from our prospect Suvain. Once you move to B2, is it easy to move back to H1?
Yes, you will get one as long as you get an approval, you'll get the approval online if you file. You file a change of status again from B2 to H1. Again, you're definitely cap exempt because you were working on your H1, so there's no question there about being cap exempt. And it's pretty easy. You file a change of status. The only issue occurs when the B2 is still pending, then you have to file a change of status based on the B2 receipt because you don't have an approval. But USCIS has said in the past that they will approve cases even based on pending petitions, and in this particular instance.
Okay. These are all the questions that I have for today's streaming session, Prashanthi. Um, For those who have attended today's session, many of you have been attending our sessions regularly, so it is a good reminder that we are hosting these webinars on a monthly basis. So stay tuned for the date for the next webinar. And yeah, if you have any recommendations, if you have questions, you can always type in your question way ahead of the webinar as well, because for each of the webinars, we do try to answer as many questions as possible from multiple different sources and platforms. So yeah, feel free to drop in your question, and then we certainly look forward to hosting you for the next webinar as well. Prashanthi, thank you so very much for your time today.
Thank you. I really appreciate everyone that joined, and for everyone that joined, thank you for listening carefully and posting all your interesting questions. And I hope that you will join us again next month for our monthly webinar series and post your questions, your comments, and subscribe to our YouTube channel. There's a lot of useful information there, and see you again next month.
Thank you, everyone.